11 workers went to their jobs at a paper mill in Longview, Washington. They didn't come home. A 900,000-gallon chemical tank imploded, collapsed inward in an instant. It became Washington State's deadliest workplace disaster in nearly 100 years. Today, we're not here to point fingers. Investigations are still underway. But we are here to talk about what families need to know when something like this happens. Because the legal system has protections that most people have never heard of. And there are more options than you may think.
And this isn't just about Longview. If you work in construction, manufacturing, logging, a warehouse, a fishing boat, any dangerous industry, then what we're covering today applies to you and your family as well.
Yeah, so here's what we know. On May 26th, just after 7:15 in the morning, a massive tank at the Nippon Dynawave Packaging facility in Longview imploded. This tank held 900,000 gallons of something called white liquor. It's a chemical mixture of sodium hydroxide, sodium sulfide that paper mills use to break down wood into pulp. When the tank collapsed, up to 570,000 gallons of this caustic chemical flooded the mill floor. 11 workers were killed. 7 more were burned or suffered inhalation injuries. 1 firefighter was also injured.
These victims ranged in age from 26 to 58. 2 of them were brothers, Tyler Covington, 29, and Bradley Covington, 27, who worked at the plant together. Jared Ammons was 35. He had 2 kids and a third on the way. CJ Duran was 26 years old and described by his family as the spiritual leader of their household. I say this because these were people, right? These were fathers, grandfathers, brothers. The community has rallied around the families. There have been GoFundMe pages, meal trains have been set up, and the local labor council has set up donation accounts.
Yeah, and there's a detail that makes this even more devastating. It happened during a shift change. 6 of the bodies were recovered from a workers' gathering area, a place where employees congregate before and after their shifts. If this happened just 30 minutes earlier or 30 minutes later, fewer people would have been in that spot.
Right now, there are 3 separate investigations underway. Rick said we're not trying to point fingers, but this is what's happening. The U.S. Chemical Safety Board, Washington's Department of Labor and Industries, and OSHA are all on site investigating. A full report could take months, but what experts are saying publicly right now is this was likely a vacuum implosion. So when you pump liquid out of a large tank, air has to flow through the vents to equalize the pressure. And if those vents are blocked, a vacuum builds until the tank will collapse inward. So that's the current theory.
So, yeah, and let's talk about what happens legally. So, the first thing families need to know is that in Washington state, every worker is covered by Labor and Industries, or L&I for short, which is our workers' compensation system. When a worker dies on the job, their family gets death benefits automatically. You don't have to prove that anyone was at fault. You don't have to file a lawsuit. These kick in no matter what.
So let's talk about what the families are actually entitled to under this statute, RCW 51.32.050. First, there's an immediate lump sum payment, which is equal to 100% of the state's average monthly wage. Right now, that's roughly $7,900. Second, burial expenses are covered. So that's up to 200% of the state average monthly wage. So around $15,800 toward burial expenses. And third, this is the big one. The surviving spouse gets a monthly pension equal to 60% of what the worker was earning at the time of their death. So that pension is for life. And if there are minor children of the deceased worker, then you add 2% per child up to an additional 10%.
Yeah, so let's put some real numbers on that. So if a worker was making, let's say, $70,000 a year, and we don't know how much they were making, but if it was around $70,000 a year, the surviving spouse would get roughly $3,500 a month for life, unless they end up remarrying. Children get benefits until they're 18 or 23 if they're still in school. And that's pretty meaningful. But for a family that just lost their primary earner, especially a younger family, it's not going to replace what they lost, obviously. It's a floor for sure, not a ceiling.
Yes, and that is by design. Workers' comp is a trade off. The worker gives up the right to sue their employer, and in exchange, they get guaranteed benefits. So they don't have to prove fault in order to get those benefits. It's what's called the exclusive remedy doctrine under RCW 51.04.010. So in most situations, you cannot sue your own employer for a workplace injury or death in Washington because of this statute.
Yeah, and that's in most situations, and we'll come back to that. So if you can't sue your employer, what can you do? The answer is third party claims. Under RCW 51.24, if someone other than your employer caused or contributed to the death, you can sue that third party for wrongful death damages. And there's no cap on damages in Washington.
So this is where it gets important for the Longview families specifically. Even though they can't likely sue Nippon Dynawave directly because of the exclusive remedy rule, they can potentially sue any other entity that touched that tank or system. And in an industrial facility like this, there are potentially a lot of hands involved.
Yeah, so let's walk through who could potentially be liable. So, number one, the tank manufacturer. If that tank had a design defect, if the walls were too thin, if the vacuum relief valve was inadequate for a tank that size, that's a product liability claim against whoever built it.
Number two, the maintenance contractors. So paper mills like this regularly hire outside companies to inspect, service, or repair their equipment. If this company hired an outside contractor who was responsible for maintaining the venting system on that tank and they missed something or did it wrong, then they can also be sued.
Yeah. Number three, engineering firms. If a third party engineer designed the venting system or signed off on the modifications to the tank or did a safety assessment and missed the risk, they're potentially liable.
Yep. Number four, inspection companies and safety auditors. If Nippon Dynawave hired an outside firm to audit safety and that firm failed to identify that this tank was at risk of implosion and they should have known, that's also a negligence claim.
Yeah. And number five, valve and instrumentation manufacturers. If the vacuum relief valve itself, the device that's supposed to prevent exactly this kind of implosion, was defective in any way, the company that made it is liable under product liability theory.
And number six, potentially the parent company could be found liable. So Nippon Dynawave is owned by Nippon Paper Group out of Japan. Depending on how much control the parent company exercised over safety decisions and budgets at the Longview facility, there could be a theory for direct liability against the parent company.
Yeah, and here's the key to that. You can receive L&I death benefits and pursue a third-party wrongful death claim at the same time. They're parallel tracks. The one caveat is that L&I has what's called a subrogation lien under RCW 51.24, meaning if you recover money from a third party, L&I gets reimbursed for the benefits that it's already paid out. But in a case like this, the third party recovery could be orders of magnitude larger than any L&I benefit.
Absolutely. You heard what Rick was saying about the L&I benefits. It's definitely a floor. And here we're talking about a severe tragedy, 11 people dead. There's no damages cap for the third party claims. So if multiple third parties are found liable, could be the manufacturer, the maintenance company, the engineering firm, like we discussed, the total exposure here could be enormous.
Yeah, and there is one exception. It's called the deliberate intention exception to the L&I, or the rule that you cannot sue your employer in Washington. And that exception, it's a big one. It's under RCW 51.24.020. If a worker's injury or death resulted from the deliberate intention of the employer to produce that injury the family can sue the employer directly on top of everything else.
Yeah, so this exception exists, but it is an extremely high bar. The standard comes from a case called Birklid v. Boeing, which is a 1995 Washington Supreme Court case. And here's what happened in that case. Boeing started using a new fiberglass material called coated in phenyl formaldehyde resin to make airplane interior parts. Almost immediately, workers started getting sick. Dizziness, nausea, burning eyes, skin rashes. A general supervisor at Boeing documented the complaints and specifically requested better ventilation, but Boeing refused. The court said, apparently for economic reasons. They kept workers on the line making this material despite knowing it was making them sick.
Yeah, the Washington Supreme Court said that meets the standard. They defined deliberate intention as two things. First, the employer had actual knowledge that injury was certain to occur. Not that it might occur, not that it was likely, but certain. And secondly, the employer willfully disregarded that knowledge. Both parts have to be met. Super high standard, very narrow exception.
Yes, it is not enough to show that the employer was negligent. It's not even enough to show that they were grossly negligent or reckless. You have to show that they knew with certainty that people would be hurt. And in that case, Birklid v. Boeing, people were already hurt. So the certainty was really there.
Yeah. And so, how does this apply to the Longview case? And that's the open question right now. We don't know yet what's in Nippon Dynawave's internal records. But here's what we do know. The company had 4 L&I safety citations since 2019. They had an OSHA serious violation in 2021. In 2025, they were cited for moving equipment before L&I can investigate a worker losing a finger. Workers filed a complaint with the state about a sinkhole from a failed drain in March of 2026. Another anonymous complaint about a faulty valve was filed in May 6, 20 days prior to the implosion. And 2 separate L&I investigations were already open the day the tank collapsed.
Now, and this is important, none of these specific complaints were about the white liquor tank's venting system, right? So as it stands today, there isn't public evidence connecting these prior violations directly to what caused the implosion. And like we said before, general sloppiness doesn't meet the Birklid standard for this exception. So you need evidence that they knew this specific tank was going to fail and that they kept operating it anyway.
Yeah, and that's right. The investigation's still ongoing. If internal maintenance records show that someone flagged the venting system on the tank, if there are work orders that were ignored, internal emails saying, we need to fix this vent, and then management saying, not now, let's just keep it running, that's a different story entirely. But this is something that we need to watch.
And if it does cross that line, if families can prove deliberate intention based on the evidence that's revealed in these investigations, then they can sue Nippon Dynawave directly for full damages, including pain and suffering, in addition to everything else. So it blows open the exclusive remedy shield completely if there's that evidence.
Yeah, and I want to broaden this out a little bit as well, because this matters for everyone, not just the Longview families. If you work a dangerous job in Washington State, here's what I want you to know. So number one, you're covered under L&I automatically. Every worker in this state, if something happens to you, your family has guaranteed benefits regardless of fault. Number two, if a third party's negligence contributed to your injury or death, you may have a civil claim worth far more than what L&I benefits provide. So think equipment manufacturers, independent contractors, inspectors, anyone outside of your employer. And then number three, document everything. That's true of most personal injury cases. The workers at Nippon Dynawave who filled those complaints with DOSH created a paper trail. That paper trail may be what helps their families. If you see something unsafe at work, report it. The Division of Occupational Safety and Health, put it in writing, create a record.
And that's true even before someone gets injured, right? Anytime you see a violation at work, report it because it will create that paper trail so that if someone does get injured, if you yourself get injured, then you'll have that evidence. And number 4, the statute of limitations for third-party wrongful death claims in Washington is 3 years from the date of death. That sounds like a long time, but evidence does get lost. Equipment gets moved or destroyed, witnesses forget. So the sooner families talk to an attorney who understands both workers' compensation and personal injury, the better their chances of preserving evidence of a third-party claim. So if there does become some evidence available that there could be a third-party claim here, you're going to want to talk to an attorney.
Yeah, and our hearts are truly with the Longview families and the entire Cowlitz County community. We'll put links in the description to the community donation funds if you want to support them directly. Thank you.
Thanks.